let's talk about duty of care for professionals. Duty of care for professionals is a very short chapter. It's actually chapter 9 in our textbook. We've talked about this already. We actually began this conversation on March 8, 2023. So that was just a few days ago. But because there's only 3 cases, and it seemed as though we moved through this module rather quickly. And because it seemed like we moved through this module rather quickly, I want to be able to provide you a resource if you need to review this information to ensure that you don't miss anything. So what are we talking about? We are talking about chapter 9, and we are talking about professional standards. Now, let's remember where we are. We are in torts. The tort that we have been focused on the most this semester is the tort of negligence. We're not really, right, it's not the introduction or the beginning of negligence where you talk about the elements, but this is really, what do those elements look like living and breathing? What do these elements look like when there is a plaintiff and a defendant? What do these elements look like when they come off of a page and they're standing in front of you and you're trying to figure out where the theory applies? Yeah, we are looking at the practical aspects of the elements. So starting with professional standards, great place to start. We're in a professional school. We all are going to graduate with a doctorate degree. Depending upon where you work, you may be called doctor. I remember before I remarried, and my last name was Ledesma, and I had gone over to see the president of my previous law school, and walked in, introduced all of the nice pleasantries and all the things that you do, and the administrative assistant referred to me as Dr. Ledesma, right? That was the first time that I had been called doctor. So all going to get a JD degree. We could all be called doctor if we choose to be called doctor. Some of us are going to go in and take a bar exam, either here in the state of Louisiana or someplace else. We're going to pass the bar so we can be called attorney, we can be called lawyer, we can be called esquire, right? There's so many titles, pick one. Why does that professional degree require consideration of different elements when it comes to professional negligence? Well, let's start slowly. Let's take a moment, let's slow down, and let's think about it. Tort cases involving professionals, like other tort cases, require the proof of the same elements. Duty, that's a duty of care. Breach of duty, that's a breach or a violation of that duty of care. Causation, we know that that's actual, also known as cause and fact, or legal, also known as proximate cause. And then we know damages, right? Tort cases involving professionals have the same elements when it comes to professional negligence as negligence when we're not talking about professionals. So what's the big deal? Why a whole nother chapter? Why a whole nother conversation on professional standards? You've told me if we're looking at professional negligence, same elements, right? Kind of. Here's the kind of. The duty of care element that is required for professionals and non-professionals is different, right? The duty of care, you've talked about it. You've talked about judge, learned hand. You've got all of that information memorized. Hopefully all of that information has imprinted upon you so that it means something. Duty of care, duty of care. What am I supposed to do? What is the expectation of what I'm doing as it relates to the intentional avoiding of injury to those who are within my zone of foreseeability, right? We've learned about this objective, hypothetical, reasonable person. Some call him a reasonable person, some call her a reasonably prudent person, but we know that that's the reasonable person who is objective and who is hypothetical. Here's the question when it comes to professional negligence cases. Is there a duty of care? Absolutely. Is that duty of care measured by the standard of a reasonable person, like all other cases, or is the duty of care that is measured for professionals based upon a reasonable professional in similar circumstances? That's the difference. What's the answer? We talked about Osborne v. Irwin Memorial Blood Bank. That's Osborne v. Irwin Memorial Blood Bank. We've already discussed it. Here's the review. The events of the case took place in February of 1983. At that, it was a case of first impression. What do we mean? It was the first case that's recorded in the nation where a blood bank was being held liable in the connection with the transmission of the acquired immune deficiency syndrome virus, also known as AIDS. So what did I just say? First recorded case in the nation where a plaintiff, that's an injured party, sues a blood bank for blood that it provided that was tainted with AIDS and that was given to the party who didn't have AIDS before the transmission, but now has AIDS. First impression. What does that mean? No binding authority, no persuasive authority. Excellent. What's going on with Osborne v. Irwin? Well, let's start the way that we oftentimes start our review and our analysis of the cases and torts. Let's start with the procedural history. Suit was filed in May of 1988. Now hold your hats, because we are not delving into these 12 different causes of action. I'll say it again. We are not delving into the 12 different causes of action. We are quickly going to turn these 12 different causes into two causes, and we're quickly going to go from two defendants, which is the hospital where the operation took place, and Irwin Blood Bank, to one defendant. But I wanted to start from the broad 30,000 feet perspective so that we can narrow down, okay? If you're reading it from the book, you're not going to get the 12 different causes of action. You're going to need to pull that off of justia.com or pull that from Lexis or pull that from Westlaw. So I'm not holding you accountable for knowing that there were 12 causes of action against two defendants, right? But as I explain it and walk through it with you, I want us to be able to actually start from the beginning. So the suit was filed in May 1988. May 1988. The First Amendment complaint included causes of action against the university. This is a teaching medical school. This is a teaching medical school university where there's a lot of actual medical care being provided, surgeries, et cetera, okay? The parents, and we'll tell you a little bit more once we get to the key facts, but there's a parent that this is a case that is brought by parents for a minor child. They sued the hospital. They sued the hospital for medical malpractice, breach of contract, intentional and negligent misrepresentation, intentional and negligent infliction of emotional distress, negligent screening of medical staff, battery, and simple negligence. Brought all of those causes of action against defendant one, which is the hospital. Plaintiffs also had a second defendant, and that was Irwin Memorial Blood Bank. Causes of action against Irwin Blood Bank: negligence, breach of contract, intentional and negligent misrepresentation, intentional and negligent infliction of emotional distress, battery, and products liability, the product being the blood. Yeah, so we've got a huge lawsuit. 2 defendants, 12 causes of action. What happens? What happens is there's a whole bunch of procedural stuff, as you would expect in a procedural history. There's a whole bunch of procedural stuff that goes on that we are not going to go into because this is not civil procedure. Okay, I've introduced you to some of the things from civil procedure because understanding the foundation of some of that procedure helps you understand why a court does what a court does, or how a court does what a court does. But we're not doing deep dives on civil procedure. So far be it to say, case is filed in May of 1988. The case is tried in November of 1988. That's really not a very long time period. Was that 7 months, 8 months? In today's timing, it would be filed, and there's a lot more time, more than 6, 7, 8 months in between, but we're in 1988. Case is filed in May, case is tried in 1988. At the end of the plaintiff's case in chief, right? You'll learn more about that when you get to trial advocacy. At the end of the plaintiff's case in chief, plaintiff goes first, call all of their witnesses. Their witnesses are subject to cross-examination. Once the plaintiff is called, all of their cases, the plaintiff will rest, R-E-S-T. The plaintiff will rest their case in chief, okay? Once the plaintiff rests their case in chief, if there's going to be any motions for directed verdict or any motions to dismiss, or any of those things, that's going to happen before the defendants begin their case in chief. Here we go. Plaintiffs, those are the parents, put on their case in chief. At the end of their case in chief, the university and Irwin, those are the 2 defendants, move for non-suits. Okay, dismiss this case. Non-suits are granted on all claims except for. As far as Irwin is concerned, non-suit is granted on everything except the negligence and the intentional and negligent misrepresentation. As to the university, all claims are dismissed except for the negligent misrepresentation and the negligent infliction of emotional distress, right? We started with 12 with 2 defendants. We have 4. We now have 4 with 2 defendants. Mr. Irwin, defendant 2, and the university, defendant 1, present their cases in chief. The trial court grants the university's motion for directed verdict on those 2 claims that were remaining against the university, right? So that means that the university puts on their case, Irwin puts on their case. After their case in chief rests, they both file motions for directed verdict. The university's motion for directed verdict is granted. What does that mean? That means the university's out. Wait, what? Yeah, no jury verdict. University's out. Nothing about the 6 causes of action that began against the university ever gets to the jury. Okay, what's left? Defendant 2, that's the blood bank, that's Irwin. And there's the only 2 causes of action left, which were the negligence cause of action and the intentional and negligent misrepresentation. Okay, that's where we are. Now, recap. Only remaining cause of action from the initial 12 are against defendant Irwin, just one defendant, and it's the negligence claim and the intentional and negligent misrepresentation claim. What do? There's a whole bunch of stuff that happens. But before all of that happens, the court charges the jury, which means gives the jury instructions, as it relates to the 2 remaining causes against Irwin, that's defendant 2. The jury returns a verdict. So the jury comes back in favor of the plaintiffs against Irwin. Okay. And the award of damages are $550,000 to the child, $200,000 to the parents. End of case. Well, not really. Okay. Defendant 2, Irwin Blood Bank, files a motion for judgment notwithstanding the verdict. Again, civil procedure. Again, we've talked about a JNOV. This isn't the first time that you've seen it. And Irwin, defendant 2, asks for a new trial. Irwin also moves for entry of an amended judgment reflecting the damage limitations of the MICRA. That sounds like a tort damage liability action, right? So at some point in the 80s, there was a lot of tort reform. So these mega $1 million judgments were now being reduced. What you could sue for was being reduced. The upper limit version, or the upper limit amount that could be awarded, was being reduced. There was a lot of reform happening in the American jurisprudence system as far as tort reform was concerned. So we start off 2 defendants, 12 causes of action. We eventually get to 1 defendant with 2 causes of action. 1 defendant, 2 causes of action goes to the jury. Jury comes back in favor of the plaintiff against the defendant, with a judgment for the child who actually suffered the injury for $550,000, and a judgment for the parents of the child in the amount of $220,000. The defendant says, don't like any of it, and we're not going to stand for any of it. So we're going to file a motion to set aside the jury verdict, JNOV, and we're going to file a motion for new trial. That's a lot. Of course, the plaintiffs oppose the motion. The court conditionally grants some motions, conditionally denies other motions. There's a lot of mediation. It feels like there's a lot of arbitration. There's a lot of temporary agreements. Eventually, the plaintiffs, who are the parents, accept a reduced award in lieu of a new trial. There's negotiations and agreements and negotiations, agreements, and it all breaks down. And we get to the point to where both the plaintiff and the defendant appeal, right? That's a long procedural history. There are some where there's very little that happens. There are some where there's a lot that happens. This is one of the ones. Osborne, the Irwin Memorial Bank, is one of the ones with a more robust procedural history. Where do we go from here? Finally, let's look at some facts. What's going on? Because there's a lot of energy here, right? There's a lot of stuff going on. What is going on? Short version. If you want the long version, I believe when I printed it, I wanted to say it was upwards of 61 pages. If you print it from Lexis, 14 font. Of course, if you print it in 12 font, it's going to be fewer pages. But this is a big case, partly because it's a case of first impression, right? Partly because it involves a 3-week-old child, and partly because it involves a 3-week-old child uh, contracting AIDS through a blood transfusion. So this is a big case. Of a 3-week-old child to the hospital in the blood bank because the child had to have open heart surgery. There's conversations, if you look at the Lexis version of the case, about the parents and the family members of the 3-week-old child who wanted to have a blood drive, who wanted to donate blood, who wanted to do all of these different things so that the blood that the child received was from, right, a relative or somebody that loves the child or somebody, right, to be able to grow up and tell the child, I gave you the gift of life, I gave you my blood, right? That all of that is wonderful, all of that is beautiful, all of that is going to work on the pathos of that 3-legged stool of the art of persuasion, where you have the egos, the legos, and the pathos. The egos, the logos, and the pathos. All of that's going to work in your heartstrings. Yeah. The child had a rare blood type, and so probably O. I don't remember if it's O positive or O negative. That is the universal donor, which means that the baby could probably donate to anybody, but it makes it much, 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 much more difficult for that O blood to receive blood from an A, from a B, or an AB, right? So the baby essentially has a rare blood type. And so there's conversation about you can round up all the people that you know, all the people that you're connected with, all of the people in your clan and your tribe, and it's still going to be such a small percentage of the amount of blood that this child is going to need. And so it seemed that that was discouraged. Okay, that's not the crux of our case. Let's get to the crux of our case. The child goes under the open heart surgery. Child survives the open heart surgery, my Lord, at 3 weeks old. But eventually the parents get notification, hey, after some post testing, we realize that some blood that may have been given to your child may have been tainted with the AIDS virus. We highly recommend that you go get your child tested. Lo and behold, the child was positive for AIDS, ergo the lawsuit. Okay. That's the long and the short of a very vast and complex fact pattern. Now, we're looking at intentional and neglectful misrepresentation, and we're looking at negligence. Those are the two causes of action that survive. What is the intentional and negligent misrepresentation based on? Statements that were made by the blood bank or by employees of the blood bank to the family about who could give blood, how much blood they could give, what kind of blood. We're not going to get into the weeds of it. Why? Because for us, what we're looking for is how, if, right? How does the professional duty of care, if it does, how does it differ in a professional liability case versus a non-professional case? Remember, start of the slide, negligence, breach. Well, you got duty of care, breach of duty of care, causation, and you have damages. Yeah, same thing for professional negligence, except that the duty of care is different. Started off with the question, is the duty of care still going to be determined by the reasonable person as it is in non-professional negligence cases? Or do we have another standard of care? Right. So we're not spending a lot of time on the intentional and negligent misrepresentation. Not that it's not important, but it's not the focus of what it is that we're trying to do. So let's move on. Those are the facts. Significant issue on appeal as it relates to Irwin is this. Listen to what I'm saying, because what I'm saying is different than the slide, and I'm doing that intentionally. So I'm taking a pause, listen to what I'm saying. The most significant issue on appeal, open parent, as it relates to Irwin, close parent, is whether Irwin was entitled to a JNOV, quote unquote, that is pulled directly from the case, that is pulled directly from the casebook, that is pulled from the Lexis version, from the Westlaw version, from the Justia.com version. If you, as Washington's tort student, in your brief identify the issue as, quote unquote, the most significant issue on appeal is whether Irwin is entitled to a JNOV, you're only going to get half the points. You're only getting half the points. We've had this conversation in different cases, and I'm going to slow down because I want you to follow me. This is really, really important. Track your syllabus. If you're tracking your syllabus, I identify for you what we are learning about is professional standards. I track for you that we're going to pull and read the Osborne v. Irwin Memorial Blood Bank case because under the larger umbrella of professional standards, we are trying to identify what the duty of care is for a professional when it comes to professional negligence. Not civil procedure, although we can't overlook the civil procedure because the only way that these things get to us is through a process of procedure, right? A JNOV is procedure. So the court is going to have to address, should they have gotten a JNOV or not gotten a JNOV? Because the trial court did what the trial court did, and we're trying to figure out if the trial court made a mistake. That's why we're in a reviewing court. But for our purposes, we are looking for what? We are looking for what the standard of care is and how the standard of care is measured in professional negligence cases. That's what we're looking for, okay? There were some names here. That was Mr. Price and Ms. Bacchus, because those are the people that I called on in class. But again, this is just a review of what it is we're doing. So let's continue with our key facts. Uncontradicted, let me say it one more time. Uncontradicted evidence that Irwin Memorial Blood Bank was doing all and everything that every blood bank in the nation was doing as it related to screening blood for the AIDS virus, right? There is expert testimony by the defense experts that said, not only is Irwin doing everything that every other blood bank in the nation is doing, the experts for the defense says they're doing more than many of these blood banks. So there's no question, it's uncontradicted, that the Irwin Memorial Blood Bank was following the standard procedure of every other blood bank when it came to trying to screen for AIDS as everyone in the country. So what's the problem? What's the problem? If they're doing what everybody else is doing, and in fact, not only are they doing what everybody else is doing, they're actually doing more than everybody else is doing. What the heck's the problem? Here's the problem. This is what we like to call a battle of the experts. Mom and dad had an expert. Their expert in blood screening and handling blood and how to screen out blood for AIDS. Okay. It appears from the record that we have, well qualified people. Nobody's saying that they're not. Probably lovely people. Nobody's saying that they're not. Here's what they testified to. Plaintiffs' experts did not testify about a standard of care. Well, what the heck did they testify about? They testified as though this was a general negligence case. Okay, what does that mean? That means that their testimony came out as what we know about AIDS today. I, Mr. Expert for the plaintiffs, would surmise or would opine that what Irwin should have done was this additional HBC test. What we know in the industry about AIDS today, I opine that they could have done that test, that they should have done that test, and had they done that test, they would have realized that that particular blood that was slated for the operation for this child, they would have learned that it had AIDS, and they would not have given the child that blood. What's the problem? General negligence versus professional negligence relies on a standard of care that's determined by an ordinary person. It's general negligence. It's an ordinary person. It's within the common purview. It's within the knowledge of a lay person, what an average lay person would do. I think it's more of a common sense kind of standard. But that's not what we call it. We call it a reasonable person in the same or similar circumstance standard. How do I know how they testify? Because that's what the record says. How do I know that they testified that this was as a general negligence case? Because that's what the record said. How do I know that they didn't testify as this being a professional negligence case, therefore addressing the standard of care? Because that's what the record says. The record says that they didn't. When they were tasked on cross-examination, I'm assuming that this is when this later information came up. When the experts for the petitioners were tasked on cross-examination, they conceded, because that's what we look for. We look for a concession or an admission. They conceded that, sure, Irwin was doing what everybody else was doing. Absolutely uncontradicted, not a problem. But what they should have done, right? So we have an expert testifying as a layperson. Whose fault was that? That's the fault of the attorney who conducted that direct examination of the plaintiff's expert. Not going to dig into the weeds, just to say what we do is extremely important. What we do is serious, and it has to be done with intention, and it has to be done with care, and it can't be done flippantly off the cuff. Because on the record, the expert is only going to answer the questions that the attorney puts to them. And this is how the attorney put the questions to the expert. So the expert wound up not addressing professional standards of care, but instead addressing general standards of care, which is determined by a general reasonable person standard. Okay. Contrast that to the experts for the defense who talked about what the professionals have done, what the professionals do, how the professionals exercise a standardized protocol, what all of the professionals in the nation who are certified blood banks following this universal protocol, and the fact that Irwin did what all the other professionals are doing. And in fact, Irwin did more than all of the other professionals are doing. So ultimately, this gets down to is the standard that is to be applied in a professional negligence case, is the standard of care to be applied in a professional negligence case, the standard of a general, regular, common, lay, non-professional, reasonable person in similar circumstances? Or is the standard of care by which the professional should be judged for professional negligence a standard that is based on the customs and the practices of the profession? What's the issue? The standard of care. Is it a reasonable person's standard of care, or is it a reasonable professional standard of care? Is in similar circumstances who relies on the customs and the practices of the profession. A professional, for many of you, because for many of you, this is a second career, and as a very quickly soon to be professional, for those of you where this is going to be your first professional career, do you want to be judged by the standards of the shoulda, coulda, woulda of a layperson? Or do you want to be judged by the by the standards of professionals who have also suffered through the challenge and been victorious matriculating through law school, suffered through the challenge and been successful, victorious in the challenge of the bar exam, and suffered through the challenge of the practice of law? Who do you want to be your judge? Who do you want to be your judge? Court ultimately says, the appeals court, the standard of care for a professional in a professional negligence case be the standard of care that is exercised by a reasonable professional in similar circumstances who follows the customs and practices of the profession. JNOV is affirmed. So we did address the issue of the JNOV, but we could not address the issue of the JNOV without addressing the issue: which standard of care, which expectations, which list of expectations do we follow? Do we follow the expectations of a layperson who is untrained, whose knowledge may not have the capacity to expand to include all of the issues that are before it? Or do we rely on the expectations that are determined by similarly situated professional people who we assume to be similarly trained, similar skill, similar expertise, similar knowledge. What is the rule of law that we take with us when it comes to professional standards? What is the standard? Is it the lay person, reasonable person, or is it the professional standard that follows the customs and practice of the profession? The rule of law is you take the professional standard that is determined by similarly situated professionals who exercise customs and practices within that profession. So what does that mean? That means if you find another problem with similar facts where we are trying to determine whether or not a professional has committed professional negligence, and we set up the elements, standard of care, breach of the standard of care, causation and proximate cause, understand that the facts that you're looking for in the hypothetical are going to be what professionals who are reasonably situated expect the standard to be. What are the practices and customs of those similarly situated professionals? That's the rule. Hopefully, that first introduction of professional standards, do we use a layperson professional standard, or do we use a professional standard that's based on customs and practices of other reasonable professionals who are similarly situated within that profession? It's a clear understanding of which standard of care we are applying. That's all I have for Osborne v. Irwin Memorial Blood Bank. This was the class that we had on March 8th. Hopefully, if you are reviewing your notes, if you are reviewing your cases, if you are working on your chart that tracks your doctrine, what the elements are, what case it is, however this fits into your body of work for studies, hopefully this helps. If this does not help and you've wrestled with it and you've tried to decipher and discern and work your way through it, and you're only left with greater and growing frustration, then reach out to me. That's the end of Osborne v. Irwin Memorial Blood Bank. And I look forward to any questions that you have. And if you don't have any, then I look forward to the next time I see you in class.